Welcome to the program. Thank you for joining us. Hopefully this will be a very interesting and very practical program. I want to thank in advance Jonathan Blotmacher, Sandy Glazer, and Joy Matak for joining me in developing the materials and speaking with us today. Tom, let's advance the slide. Keep going. Before we get started, let's just have a quick comment from Interactive Legal, who's one of our sponsors, and then we'll go on.
Absolutely. Thank you, Marty. My name is Teresa Bush. I'm the Director of Education and Support for Interactive Legal. And Vanessa Canega, as you see on the screen, she's our president. She is speaking in Colorado today, and I'm actually speaking in San Diego, but we wanted to make sure to welcome everyone. And so on behalf of Interactive Legal, I'd like to do just that and also extend our thanks to all of the speakers. As I said, I'm currently in San Diego at the Tax and Estate Planning Forum, and some of the issues that they're going to discuss today on this webinar have already been mentioned here in some of the sessions, particularly pre-election planning. So I look forward to the discussion and to keeping Interactive Legal updated with options to assist all of our clients in these changing times.
Thank you, Teresa. I will also
Hey,
say,
Marty, this is Jonathan. Marty, have you ever looked at Interactive on their system of artificial intelligence and drafting?
I've actually done more than look. I think I'm actually on their editorial board. I transform my practice using Interactive Legal document drafting software. And if anyone on this call has not adopted some type of document generation software, I strongly encourage you to give some thoughts to it. As we go through the program, and the guts of what we're going to focus on is what to do in 2019 in anticipation of the 2020 election, and what you need to tell clients, and more important, what you need to do when you get them in the office. Every technique we're going to talk about, and I'll ask Jonathan about one, every technique, with the possible exception of one, which if it's not on, will be on Interactive. You can draft all these documents that we're going to discuss with Interactive. And the beauty of having document generation software is you can pick and choose and tailor documents with incredible ease and speed and low cost to really accomplish a myriad of objectives. Jonathan, do you know if they have a SPAT form? And if you're not familiar in our audience with SPAT, Jonathan's going to explain them when we get to that point in the program. Is that on Interactive yet, or is it coming?
It will be there by the time of Hackerlink. I mean, It's possible to do it now, but it'll be even more simple by the time we get to Hackerlink on January 13 or 14, whatever that date is.
Okay, great. And we're going to talk more about this in a practical sense as we go through it. Let's go on to the next slide. And our second sponsor is Peak Trust. I think we have Matt Blotmacher, who is going to make a quick comment.
Yes, good morning, everyone, and thank you, Marty. We have a great panel of speakers today, and we're honored to be able to, be associated and support these fantastic minds. My name is Matt Blotmacher with Peak Trust Company. Unfortunately, Brandon is sick today, and so I'm substituting for him. It's a poor substitute, but I'll do my best. For those that may not know, Peak Trust Company is formerly Alaska Trust Company. We're a full service provider of fiduciary services, focusing on trusts. Services in Alaska and Nevada. We handle all shapes and sizes, including the difficult ones. We're very interested in today's topic as our clients and their advisors start to think about what might happen in 2020. It seems somewhat reminiscent to 2012 discussions of what might happen, and of course that unknown creates great planning opportunities for clients and their advisors. So we're happy to be here this afternoon and look forward to the presentation.
Hey, Marty,
Matt.
this is Jonathan. Jonathan again. Have you ever heard of Peak Trust or Alaska Trust Company before?
A few times. I have scores of trusts for clients that work with Peak. They're quite incredibly efficient. What we're going to talk about in some of the 2019-2020 planning is going to be among a number of different techniques are non-reciprocal spousal lifetime access trusts. And one of the ways that we differentiate SLATs to avoid the reciprocal trust doctrine is we try to use different states and different trust companies. So my SLAT that I created for my wife and family is with Peak in Alaska. The SLAT that my wife created for me and the family is in Nevada with a different trust company, different state law. One of the speakers has a lot of background noise. Could you try to mute? I'm not sure who it is. Tom, let's go on to the next slide. Keep going. One more slide. So the big elephant is we don't know what's going to happen in 2020. The Democrats, if they sweep, all the Democratic candidates have been talking about much more severe estate and even wealth taxes on wealthier clients. The levels and amounts at which those will hit are uncertain, but I think we have a pretty good model of what they may look like with the very detailed bill that Bernie Sanders proposed in the Senate in, I believe, April. And we're going to talk about that because I believe that the Sanders bill is the model of what a Democrat will propose if a Democrat takes over in 2020. And by the way, even if they don't, we all know that in 2026, the exemptions are cut by half. And who knows what the economy and deficits will do before then. There could be action, even if there is no change in Washington in 2020, earlier than the 2026 cut in half of the exemption. But the key focus of what we want to do is give you all a roadmap of planning ideas and strategies to focus on with clients now in 2019. What do you do now in 2019 in anticipation of the potential of a change in 2020? I have no idea, nor do any of us, what the likelihood of a change in 2020 is. It's certainly less than 100%. It's certainly more than 0%. And for wealthy clients, I think it's foolish and mistaken not to take action now. Just so you all know, we're going to have a second follow-up roadmap trust planning webinar on the 28th of October. I think that's a Monday, also at noon. And in that program, we're going to go through more sophisticated planning techniques for larger estates. So please join us for that. The announcements for that and the invitations will go out probably starting later today and next week. Let's go on to the next slide. So planning before the 2020 election. First thing, and just very quickly, is there was some speculation. What happens if I made a gift of $10 million? Will that, when the exemption drops to $5 million inflation adjusted in 2026, will I somehow lose via recapture the excess exemption I've given away? And the regs were issued earlier this year saying, no, that's not going to happen. This is a great incentive that confirms why clients should plan now. If we have an $11.4 million exemption, let's use it before we lose it. And we're going to talk much more about why 2019 is so important to start that process. Let's go on to the next topic. Stop. So the Bernie Sanders tax bill was proposed in April. It's never going to get enacted with a Trump White House and a Republican Senate. We all know that. But I think what's important is I really believe this is going to be a template for what any Democrats would propose if there's a Democratic change in control in 2020. And the things that Bernie Sanders proposed in his legislation, for the most part, were not new. Many of the restrictions and changes were straight out of President Obama's Green Book. So these are things that have been on the table for a long time. And I think the bottom line, second bullet point, slide 14, clients should choose to act now to secure the benefits before the election. Why is 2019 so important? Because there's planning that if we can convince clients to start planning now in 2019, we can do a much better job and a safer job of planning for them than if they wait. And Matt Blockmacher said earlier, this is kind of a little bit like 2012 in the sense that we have an exemption. We know it's going down for sure in 2026, but it may go down after the 2020 election. And there should be a tidal wave of clients rushing our offices to do planning. I don't quite think that's the case yet, although a lot of the very wealthy, I think, have been planning aggressively since the election and realization that if Trump couldn't repeal the estate tax, it's probably not going to get repealed in their lifetime. But we need to educate clients and show them some of the tools we can use to help them plan better, safer, and so on if they start now in 2019. I'm going to tee up that discussion of the planning, which is where we're going to really take our time and walk you through techniques, including Jonathan will explain a new concept that he has that's fascinating called a SPAT, because you needed another acronym. But I'm just going to run through quickly to tee it up what some of the Sanders proposal has. So let's go through the next slide. We're going to go through this quickly because, again, I'm just trying to set the stage. Sanders tax proposal, $1 million gift exemption. Bottom line, if clients don't use their gift exemption now, $1 million gift exemption is going to really freeze out much of the planning that clients would want to do after the election if it changes. So people need to plan now. Also, $1 million gift exemption. These changes, and meaning planning that clients should start pursuing now, are not just for the ultra wealthy. If you have a physician client with a $3-4 million estate, if we end up with the $1 million gift exemption, it's going to be very hard for them to plan for asset protection with a small exemption like that. Even much lower wealth level clients that are on most people's radar need to plan now. GST and estate exemption, $3.5 million. So that's back to 2019 figures. Radically transforms current planning. People need to do this stuff now. Next slide.
Yeah, Marty.
Consistent. Yeah.
Marty, this is Jonathan. Let me add that there's another proposal, and this is again one that's been around for a long time. The annual exclusion would drop back to $10,000 per donee, but only $20,000 per donor. Now that means again you can make lots and lots of small gifts throughout the year to as many people as you want. So holiday gifts, birthday presents, graduation presents aren't going to be there. But the ability to avoid estate and gift tax by using the large, annual exclusion we have now of $15,000 for as many people as you want will be gone. This is something that the Treasury has wanted for a long time. They've tried to attack crummy trusts, but this one will really put a damper on planning, especially if you're quite well-to-do and carry a lot of insurance as Marty does, and you're paying, tens of thousands of dollars a year in premiums.
But let me just expand on what Jonathan said, because that's kind of one of the key points of this overview of what Sanders proposed, because I do think it's going to be the foundation for any Democrat proposal if they sweep in 2020. It's not just the lower exemption. These proposals that we're running through pretty quickly, because again, I want to focus most of our time on planning. These proposals emasculate almost all the planning that we know. So if you have a lower exemption, well, golly, you could use, discounts with FLPs and annual gifts. You can't. All those things are gone. We're going to go through some more. Let's go to the next slide.
Well, Marty, let me also say one thing you had up there on basis consistency. Of course, for most people now, the tax-free step-up in basis is the more important thing than avoiding estate tax. The problem is we don't know which of those is important, and I'm completely in Marty's camp. We've got to have people do their transfers now before the law changes to try to get some sort of grandparenting in effect. But what if we want to get it back in the estate? You've done a magnificent job using whatever tools you want, installment sales, your grantor trust, grants, whatever it happens to be, and you've moved, millions of dollars out of the estate, but now you want that tax-free step up in basis. And Marty, if you'll give me an opportunity later, I'll tell you how I think you can do it both.
We will. We're going to focus on that kind of planning. I'm going to spit out one idea now because I'll probably forget it later. One of the techniques you may use is if you set up a domestic asset protection trust in a jurisdiction like Alaska, which permits them, and your client lives in New Jersey or New York, which don't permit them. If you have a change in status clause, you bring the trust back to that jurisdiction, and arguably it's back in their estate. Let's go to the next slide. Valuation discount, emasculated. We thought 2704 sounded like the regs that were proposed a few years ago that would have emasculated discounts sounded horrific in terms of the planning implications for many of our clients. Take a look at what was in this proposal from Bernie Sanders that may well be in any Democratic proposal. Second bullet point, no discounts if the transferee and family members have control. Let's go on to the next slide. Discount planning could be gone. GRAC this is again stuff that was in the Obama proposal, 25% of trust value, $500,000 gift. If you can't zero out a GRAT, you're not going to be able to effectively use a GRAT. Minimum 10-year term. Older clients will never be able to use GRATs because they're going to rarely outlive them. The long-term GRAT planning technique will be gone, but that may be a cute planning idea to use now. So the bottom line is GRATs could be gone, discounts could be gone, annual gifts could be gone. I'm going to ask again, one of the speakers or somebody has their phone on and there's a lot of background noise, please mute it. Let's go on to the next slide. Grantor trust. This is incredible. Your estate will include assets in a grantor trust. If there is a grantor trust, which has been the foundation of much of current planning, those assets will be back in the settlor's estate. It completely emasculates planning as we know it. If you want to get an asset out of the estate, you have to use a non-grantor trust. If you want to make a sale transaction, you are going to absolutely face an income tax hurdle that could prevent that. So one of the things that we want to talk about now is getting grantor trust in place if clients don't have them, so they are grandfathered, or as I think Jonathan said, grandparented. This is critical. Clients that want to do planning now or safeguard their future planning possibilities need to get this stuff done now. We can't even guarantee them what the effective date will be. Maybe there won't be a grandfathering, but it certainly makes sense to try. Let's go to the next slide. GST tax. A trust after 50 years will terminate for GST purposes. Doesn't mean the trust terminates, but it means that there's going to be a GST tax assessed every 50 years. The compounding of assets outside of the estate over generations is one of the most powerful estate transmission tools that we've ever had. This will emasculate that as well. Again, makes sense for clients to get assets into GST exempt grantor trust today. So hopefully they'll be grandfathered if grandfathering is permitted. Let's go on to the next slide. Jonathan already talked about this. Think about what these annual exclusion limitations mean. They mean that the most common planning tool, an irrevocable life insurance trust, will not be able to be funded. Think about what it means to insurance trusts now. You may need to get clients to fund large gifts to ILITs today so that if this cap is put in place, they'll still be able to fund their insurance premium. Think about durable powers of attorney. You may want to modify the language in the standard power of attorney forms you use because many of the standard forms cap gifts based on annual exclusion limits. If all of a sudden there's a $20,000 annual limit and the client had a $40,000 premium, they may have been making payments to that insurance trust for years. If they're incapacitated, those premiums won't be able to be funded through gifts because the cap in the language in the standard power of attorney. Maybe you add, in addition to the annual exclusion, that the agent can fund gifts to insurance trusts that have been historically done. Let's go on to the next slide. And I'm sorry I'm rushing, but I want to get to the thinking about the planning because that's really the focus of what we want to talk about today. Consider upstream planning. Every webinar, seminar, conference, all talked about upstream planning. Jonathan did a great presentation on upstream planning at Heckerling last year. It's certainly something we have to talk about, but be careful to make sure that you go back and verify that upstream planning's been done right. So I'm going to set up a trust, a flat for my wife. I'm going to give my elderly mother who has no estate general power of appointment, so it's included in her estate. Well, that may have been great. If the trust has, $5 million in it and mom has a $2 million estate, under current law, we got no issue. Full basis, step up, no estate tax. If we end up with a $3.5 million exemption, I've just triggered an avoidable, unnecessary estate tax on my mother's death. Is that really appropriate? Make sure to rethink upstream planning in the current environment and make sure it was done with flexibility so it can be triggered, but is not automatic in case it's going to trigger an inadvertent estate tax. Let's go on.
Well, Marty, let me just say one thing about that, because that upstream planning, I think, is very, very important to consider. I happen to have an uncle who's 99 years old, and I think he will probably pass on before 2026. So I could, try to do it that way. But it really is something you need to be careful of. If you're really planning on getting a step up in basis, you better make sure maybe your elderly relative is going to die soon, But again, with the Sanders proposals, even my uncle may survive that, and then I would have made a gift to him because I'm going to have to make a gift. He would have a general power, and if there's enough money involved, there would be an estate tax when he dies with respect to the assets over which I wanted to select that basis.
So again, upstream planning is great. Just be mindful. You want to make sure it's done flexibly so it's not an automatic trigger in case an estate tax under a new democratic regime could be triggered. Now, we're talking now about planning now, what we can talk to clients about now. So let me propose something that I haven't really heard being talked about at all. And for our very, very wealthy clients, I think it's a very intriguing concept, and I'm going to propose a way to do it, and then we'll let the other panelists comment. So everybody's talking about upstream planning. What about downstream planning? What am I referring to and why? Our focus has been getting assets into grandma's estate or Aunt Nellie's estate because she has no assets. We'll get a step up. Refocus. If the exemption is going to go from 11.4 million down to 3.5 million, we have a massive amount of exemption that the children of our wealthy clients, the heirs of our wealthy clients, have not used. So if you have a client that's got 4 children, you're talking potentially almost $45 million of exemption that will be, you could be talking, $20 million of exemption lost if no planning is done and the law changes. So here's a thought. Where we have really wealthy clients, they can't give money to their children to make gifts because they've all have or should be using their exemption. How can we get money to a wealthy client's heirs so they can use their exemption, which is such a valuable asset, to start growing assets outside of their estate, so they can get a GST-exempt grantor trust in place that hopefully may be grandfathered? What if the following were used? If mom loans money to child, can child then take that money and make a gift and get their planning set up? That would work, but there's one problem. If the child doesn't have adequate resources, and in most of the cases I've seen they don't, or they've already done their own planning, that is not going to be treated as a loan or respected as a loan. It'll be recharacterized as a gift because there's no basis to have made a loan. What can we do to get around the gift treatment of a loan from mom to child so child can fund use of child's exemption? What if one of the existing dynasty trusts from this wealthy family guaranteed the loan that mom made to child? Maybe that would suffice to be able to capture some of that exemption. Just a thought, suggesting some new perspectives on planning if we're going to face a major change. Jonathan or others, do you want to comment?
Well, Marty, I think that the safest thing to do to show it really is a loan is for the child to borrow the money from a third party, like a bank, and maybe let the trust for the child, and there's probably some around to guarantee it. Guaranteeing something for a beneficiary is not considered a distribution of the beneficiary. I mean, you're going to document it, paper it up exactly right. Now the children will have assets with which to make to use their exemptions. And I think that's a bully idea. So, each child could make gifts. Now, one question is, suppose you have minor children, how are they going to make gifts? Well, one way is to have a trust where they have a general power of appointment and to provide that their guardian can renounce the power at a certain point. That probably would be a gift by the child, because when you lose a general power, you're deemed to have made a gift. But I would think about that very, very carefully before you jump into downstream planning.
Let's go on to the next slide. Just trying to give you planning ideas and thoughts. Now, here's the real crux of this, and let's pause before we go into how to structure some of the gifts and some of the receptacles or trusts or techniques that can be used for the gifts. And let's just talk for a minute, and I'm sorry I didn't put a slide on this, why it's so important to encourage clients to start now, 2019, not in December 2020 after the election, and then they find out, oh gee, Elizabeth is the new president and maybe we should plan. Here's why, and then after I make some general comments, I'd like to open it up for Sandy or Joy to comment. if I can get a client to start planning today in 2019, I think I can lessen the risks of a step transaction challenge to the planning. For example, let's say husband has most of the wealth in his name, and in order to use wife's exemption, he's going to give assets to wife for her to fund a trust, which we'll talk about. If the husband makes the gift in 2019, and then time passes and only later in 2020 does the wife fund a trust, you not only have time in terms of, say, weeks and months that goes by, but you also have a different tax year from the gift, so that the gift and the asset that was generating income from the gift is reported on wife's return. And then next year, after she's held that asset, reported it or reflected the income from it on her income tax return, then she funds a trust. Putting a calendar year break between a gift from, let's say, one spouse to the other, and then the donee spouses funding a trust, I think can help reduce the step transaction doctrine. Another point, if let's say husband and wife are going to do
Go ahead, Sandy. That's okay. Marty, I couldn't agree more with the importance of creating distance between not only the gift from the husband to the wife, but even in a scenario where the husband and wife each have assets sufficient to be able to make a non-reciprocal trust for the benefit of the other, that distancing between them, I think, still is important. Not only do you want the terms to be different between the two trusts, but I think timing differences also help.
We all saw the problems with this in 2012, and we unfortunately didn't have a lot of options, because when clients showed up in November 2012 and wanted to make gifts and we set up non-reciprocal slats, we didn't have the luxury of a lot of time between each spouse setting up their slat. Right now, if we can get a client to come in and set up a slat, one spouse this year, say husband in 2019, wife in 2020, that will help differentiate the trust, because they'll have been created in different tax years, plus the time that can lapse that's passed between one spouse, the first spouse setting up a slat, and the second spouse setting up a slat. So getting clients to act today is a great way to help reduce not only step transaction risk, but reciprocal trust challenge risks. And let's say the client's not convinced.
And I had another thought, Marty, on that, because this is Joy. Another thought on that is that you can also take better advantage of discounts and get more out. So by way of example, if I had a limited liability company that owned a parcel of real estate and gave 100% of it to a trust in 2019, I would not be able to get any discounts for that transfer. However, if I were to give 49% of it in 2019 and then wait some period, you know, in not in a plan, but, you know, just because next year we see the election come down and the spouse then decides, oh, hey, I'd like to give away my half of it, that would then help you to leverage it out of the estate using discounts.
Good point. The key is that we need to educate clients. Listen, you may not be convinced that the change is going to happen in 2020, and you may be right. But in 2026, the exemption's cut in half. It's really prudent, if you're of means, to do planning. And by the way, if you start the planning in 2019, you get the safety and the benefits that we all just discussed. So maybe you set up one of the non-reciprocal slats this year. Maybe you only put $1 million or $2 million in it. And then next year, the other spouse in March, April, May, after time has gone by, sets up his or her non-reciprocal slat. Maybe they only put $1 million or $2 million in it, because that way, at least the trusts are in place. If we have the planning structure in place and the client doesn't act further until after the election, and you need to pull a trigger quick, it's a lot easier to make last-minute wire transfers of securities or cash, ACAT securities or wire cash into an existing trust than to start the whole planning process at the 11th hour, which is what we all faced, as Matt Blattmacher said earlier, in 2012. Jonathan, are there any other thoughts on why it's so critical that people start planning in 2019 and not wait? We may,
Well,
did
Mark,
we lose you,
maybe
Jonathan? Oh, I'm sorry.
yeah, there may be one other advantage. People have to do things to protect their assets, and they want to consider asset protection trusts, and later I'll talk a little bit about the SLAT. But if you can establish that you're making transfers in trusts because of the potential loss of the large exemptions, and you're doing this for estate tax planning purposes, I think you're going to be golden. After the Alaska Trust Act passed in 1997, I was invited by the bankruptcy judges of the United States, and all bankruptcy judges are federal judges in our country, to attend their annual meeting. And one of the reasons they said they invited me was not just for my good looks and charm, but to have me tell them about this extraordinary thing that had happened in Alaska, which is permitted self-settled trusts. Every one of those judges indicated that he or she would not cause those assets to be in the estate if you could establish that the principal reason you were doing the transfer to the trust was for estate planning purposes. And indeed, when I came up with the Alaska Self-Settled Trust legislation, it wasn't because I wanted to help people bill creditors. I personally think that's quite offensive. It was because people were hesitant to give property away because they might need it later in their lives. And having a way to get it back through a self-settled trust, for example, was really something they wanted to do, but they also wanted to do good estate planning. So one of the things I would suggest you do is to make sure that your clients establish that they're making these transfers now, not to bill creditors, but in order to get good estate planning, and yet because these amounts are so large that they want to have access to that property if they need to later in their lives.
We're going to come back to self-settled trust because that's really one of the more important tools that we need to talk to clients about now. Sandy and/or Joy, would you like to comment on why in the current environment, moderate wealth clients, say $10, $15, $20 million clients, may want one spouse, not both, to make gifts?
Because what would wind up happening in that situation is that in the event that the exemption were reduced down to something more moderate, or if under 20, if the under the current TCJA it just sunsetted at the end of 2025, then on January 1, 2026, the one spouse would still have approximately $6.5 million of exemption, whereas the first spouse who made all of the gifts during this time period would have no exemption. So the idea is that they would continue to have exemption even after the current law sunsets, and that is probably a prudent thing for them to have.
When we're taking a look at the structure for these gifts that we're talking to clients to make, which again should be really looked at starting this year, in some instances, depending on the wealth level of the client and how much they're willing to give away, and give away should be in quotes because if it's to a self-settled trust or a SLAT or some of the variants we're going to talk about, they still have access. But it may be more prudent, as Joy just explained, that one spouse, not both, make gifts. The knee-jerk reaction from many advisors that I see is non-reciprocal SLAT. And while non-reciprocal SLAT is a great tool, in some instances, it may not be the optimal tool. So let's go on to the next slide.
Well, and the other issue, Marty, is unless there can be a replacement sometimes for the death of one of the spouses in terms of the surviving spouse needing access to money, and if they're not insurable to be able to replace that loss with a life insurance policy, and some people are a little concerned about the ability to, whether it'll work if you give a trust protector or a trust director be able to give the right to the surviving, to have a general power of appointment or a power of appointment to appoint back to the gifting spouse. You may want to have assets that aren't tied up in all the trusts.
Great point, and we're going to come to that and elaborate even more on what Sandy just said in a minute. So the key point in some of the things that was just said from Sandy and Joy and I and Jonathan is you got to preserve access because clients, especially moderate wealth clients, are not going to give away enough money to make a dent in their exemption. unless they can have access. As Jonathan said, they may need it later in retirement. How do we do that? One of the techniques that would seem to assure that ability is a domestic asset protection trust, a self-settled trust. I can set up a trust in Alaska. I can be a beneficiary of the trust, and yet it's still arguably out of my estate, not reachable by my creditors. The beauty of that is I've used my exemption, but I've preserved access to assets as a discretionary beneficiary in the discretion of, say, an institution like Peak Trust to give me a distribution. Jonathan, I'm going to challenge you. Can you, in like 2 minutes or less, give a little summary of the current state of affairs of DAPS and some of the recent cases, and maybe give some comfort to some of those that are naysayers? And we'll also talk about SPATs and other options in a minute.
Well, Marty, it's pretty tough to do that in a couple of minutes. There have been challenges. Typically, what happens is that there's a case out there called Hubert, there's a case out there called Tony One versus Wacker, and those are cases where they were actually Alaska trusts didn't work for asset protection. But in both of those cases, there's no question in my mind that they were fraudulent transfers. And I don't care what state you go to, if you've made a fraudulent transfer, you're not going to get any comfort. But on the other hand, if you have an independent, non-asset protection reason, like using your exemption but making it available to yourself and your family, I think you can get it made. Now, by the way, there is some interesting developments with respect to foreign trusts. There's a case recently where a person in Florida created a trust in Belize with a Belize trust company. And later, she fell on hard times. She added additional assets to the trust, and the trustee converted those assets, which were not exempt from creditors under Florida law, to an exempt asset, an annuity, because under Florida law, an annuity is protected. And even though the trustee had the annuity payments payable to the settlor of that trust for the balance of his lifetime, they said that that did not fall under the rule in Florida that if you convert a non-exempt asset to an exempt asset, the exempt asset is still subject to claims of creditors. But the bankruptcy court in Florida, again, it's a federal court, said no, because the settlor didn't make the conversion, the trustee made the conversion. You don't have to worry about it. Now, by the way, that happened to be a foreign trust. You could do it as a domestic trust as well. And certainly, if you're from Florida, you should think about having your clients add assets to a self-settled trust in Alaska, Delaware, South Dakota, Wyoming, wherever you want to go, but then convert it to have the trustee convert it to an exempt asset. But there's no question in my mind, if you make a fraudulent transfer, you're going to lose. If you make a transfer for estate planning purposes, I think it's going to be respected. So that's the thing you need to focus on, the thing you have to emphasize to your clients, and it should be all good.
So let's go to the next slide. Couple of comments. And this is also why I think it's important to get clients to start addressing planning in 2019 and earlier in 2020, not after the election when we have no time and replicate the stress of 2012. So if you want to avoid a fraudulent transfer, if you want to corroborate that there isn't a fraudulent transfer if a DAP is being set up, you want to get financial data on the client. Ideally, it'd be great to have the client's independent CPA prepare a financial statement. You want to get, even if state law doesn't require, you may want to have a solvency affidavit signed by the client. You may want lien judgment and other searches done on the client, title searches on the real estate, all these things to try to identify and show or corroborate that there's no claims or issues outstanding. Maybe you have the client's wealth advisor, financial planner, create a financial forecast that shows that even after the gift to the DAP, the self-settled trust, the client has plenty of money to live on and can maintain their lifestyle. All these things take time. In 2012, it was probably impossible in the vast majority of transactions to do the kinds of things that I just said because there was no time when clients came in so late in the game. So if clients would start the process earlier, like 2019, lots of time to do it. Another approach, if you put assets into a DAP this year, let's say you set up an Alaska self-settled trust, you put $1 million in it, you do all the safety measures that I suggested you may want to consider. Next year in March, you put another $1 million. December next year, you put another $1 million. You know, you're not putting the bulk of all the assets in at one time. You're spreading it out over time. That may look better because it is perhaps less likely that each of those transfers is as large or potentially recharacterized as a fraudulent conveyance. Again, we want to get clients to start planning now. Now,
and Marty,
yeah.
there are non-tax reasons for doing DAPs as well. I mean, if you use them as a belt and suspender to premarital planning, you can even do it as postmarital planning in many of the states if you get a spousal waiver. And I find them particularly helpful, or I have clients who are interested in them when they have special needs children, that they want to make sure that in the future they're able to leave assets to be able to take care of those special needs children in trust, but they may need those assets at some point in time during their lifetime. ADAPT is actually a vehicle that works very well.
So, thank you. Sandy and I wrote an article that explored using DAPs as prenuptial agreements. Our email addresses are on the last slide. Either of us will be happy to send it to you because we did not include it in the materials. Slide 28, and I want to ask Sandy and Joy and Jonathan to speak. We now have 19 states that permit self-settled trusts. So those naysayers that were saying that the concept didn't work when Alaska in 97 became the first state to enact DAP legislation, I think followed fairly quickly after that by Delaware. We're now up to 19 jurisdictions. That's a fairly significant number. But there's lots of different variations that you can use of the traditional DAP. For example, you could provide, one of the issues is under Section 514E of the Bankruptcy Protection Act of 2015, that if you make a transfer to a self-settled trust or similar device, whatever that may mean, within 10 years of filing for bankruptcy, that the bankruptcy trustee can overturn or pierce the trust. So what if you structure a trust that you cannot get a distribution out of? Yeah.
Marty, let me add that rule in Section 548E of the Bankruptcy Code says, yes, the trustee can in bankruptcy can grab those assets which you put into a self-settled trust or a similar device within 10 years, but only if it can be established you did it to hinder, delay, or defraud creditors. And that's why you want to show you weren't trying to hinder, delay, or defraud creditors. You were trying to do good estate tax planning.
Thank you. So, but the point is there's other options. Maybe Joy, Jonathan, there's other ways to structure a trust so that it can still benefit you, but not initially be a self-settled trust. Joy, Jonathan, you want to comment? And then we'll ask Jonathan to talk about SPAT.
So if you were to structure a hybrid DAPT where someone else could appoint you as a beneficiary, you have to be very careful in how you structure it, but in that way you could create a trust that you could then be a beneficiary of while still gaining the domestic asset protection that you're looking for by setting up the trust originally. Additionally, and I think Jonathan really should maybe, this may be the best time for him to talk about the special power of appointment trust, because that's the next best thing, I think, that's coming down the pike.
Let me just clarify before you talk, Jonathan. What Sandy was mentioning in this concept of a hybrid DAPT, if somebody is given in a non-fiduciary capacity the power to add you, or even sometimes people say the beneficiary, descendants of your grandparents, to a trust, until that power is exercised, the position is that trust is not yet a self-settled trust, so that any risks that are perceived that apply to DAPT should not apply. Jonathan has another approach which he can explain now. And Jonathan, when you explain it, explain why it's so critical to look at in the context of people shifting large wealth before the 2020 election.
Even though we have 19 jurisdictions in the United States that will respect the self-settled trust, again, none will, however, respect a trust if the transfer to it is fraudulent. The problem is that many states, take New York, for example, have a law which basically says a self-settled trust is void with respect to the settler's creditors. when you look at all the law, a self-settled trust is one from which the trustee must, or in its discretion, may distribute assets to the settlor. And as was just stated, maybe you want to start with a trust where the trustee can't, but maybe later can do it. What I've done, if you take a look at the February issue of the asset protection, the estate planning magazine, you'll see a concept which Mitchell Gans and Abby O'Connor and I wrote up called the Special Power of Appointment Trust. And here's the way it works. I create a trust for my family, and I expressly provide that the trustee under no circumstance can make a distribution to me. Yet I name someone, maybe it's my brother, maybe it's my 3 eldest cousins, any one of whom has a power of appointment held in a non-fiduciary capacity and who is not a beneficiary. When you hold a special power of appointment and you're not a beneficiary, that's known as a collateral power of appointment. And there's a long history of that in the common law. It's not something I made up. It's been out there for centuries. And it basically provides, so I give my brother, who's not a beneficiary of the trust, and he is not a fiduciary, has a special power of appointment held in a non-fiduciary capacity to appoint assets back to me or to a class that would include me, for example, the descendants of my mother. So you can go ahead and do that. You do not have a self-settled trust. And like Section 548E says, this special rule about going bankrupt within 10 years applies if you've transferred assets to a self-settled trust or similar device, whatever that means. But it also means that where you have a state law like in New York, EPTL 783.1, which says the self-settled trust is void with respect to creditors of the settlor, that is not going to apply because the trust by definition is not self-settled, because a self-settled trust is only one where the trustee must or may make distributions to the settlor. Now, in theory, you could create this in any trust in the United States. And for those of you who are now saying, well, I really wonder that, I'll bet you've done trusts in which you've given the beneficiary a power of appointment and have not prohibited that power from being exercised in favor of the settlor. So, and you felt completely comfortable that that was out of your client's estate, that there was no creditor problem. The fact that someone can exercise a power of appointment in a non-fiduciary capacity doesn't make it a self-settled trust. So if you're going to do that, you want an asset protection trust, I would suggest you consider a SPAT. And even though it could be done in New York, California, Florida, anywhere, even though they don't have self-settled trust legislation, you ought to create it probably in a self-settled trust jurisdiction so you have belt and suspenders to hold up your pants.
So again, just for context, we have an exemption that's going to be cut by half for sure in 2026. After the 2020 election, we have no idea which way it may go, but if the Democrats take over, it seems pretty assured that if they get enough control in Washington, they're going to devastate what we know as estate planning. Clients of even moderate wealth should be doing planning now in advance, because by doing planning starting in 2019, we can greatly lessen the risk, lessen the pressure. They can tiptoe into the planning in a more comfortable way, and it makes a world of sense to do. The key for a lot of our clients is preserving access to assets, and these variations of spousal lifetime access trust where the spouse is a beneficiary. You can use a floating spouse clause, so a future spouse can be a beneficiary. Hybrid DAPs, DAPs with a 10-year and a day wait, special power of appointment trust. You can use all sorts of combinations of these in the planning to accomplish the client's goals. Let me go back to a comment I made in the beginning when Jonathan asked me if I had ever heard of interactive legal. I think if you practice by having a template of standard forms in a firm, you are handicapping yourself, because how can you possibly pick and choose the right combo of these trusts to do the best job for a particular client's circumstances? If you're using document generation software and click, click, click with some selections, and you think through the planning process as you're doing it, you can create some really tailored, specific, nuanced plans for each client that incorporate the right elements of everything we've just talked about for that client. And that's the beauty of using document generation systems. And that's something that as 2019 and 2020 continue to unfold, I think all of you should do if you haven't done. because it's going to enable you to do a much more robust job, much more cost effectively, and really tailored to the client. Let's go on to the next slide.
Marty, before we do that, I do want to, I think the last sentence of that bullet point is really important. The issue that you can trigger grantor trust status is important for people to understand in who they're selecting. And the problem becomes one if you're picking somebody in, and especially you want a non-fiduciary, because the fiduciary is going to have a problem with a breach of fiduciary standard if they now add another beneficiary in, such as the settlor, because the duty at that point would be to the named beneficiaries. So these are nuanced things that you have to keep in mind and talk to your clients about.
I think that's a great point, and you have to be mindful of that in lots of things that you do. There have been so many provisions with trust directors, trust protectors, and other power holders that, you know, can they even act in a fiduciary capacity? In a lot of cases, you don't want them to, but in a lot of cases, as Sandy pointed out very appropriately, they can't really do it. So you need to be mindful of all of that. Let's go on to the next slide. We've already covered this, and again, just slats and all the different variations of what you can do to give access and help clients. Let's go on to the next slide. So there's a range of things that could be done in order to provide access beyond just the structure of the trust. So if the client has a business entity, they can earn reasonable compensation out of the business entity. You may have further restrictions on when somebody can exercise the power to direct assets under a SPAT to the client, or when somebody can add the client back. You may provide that the person in a non-fiduciary capacity can only add the settlor back as a beneficiary if the settlor is not married or has no spouse, and so on. Let's go on to the next slide. Lots of variations that you can all look at. On slide 31, I just wanted to point out there's yet further ways to get access to a client. For example, we've traditionally used the power to loan. Somebody in a non-fiduciary capacity can direct that a loan be made to the settlor without adequate consideration. Pay adequate interest, but no adequate consideration. That would create grantor trust status. Leaving aside the income tax status of the trust, being able to have somebody loan money or direct that loans be made to the settlor is a great way to access money. A floating spouse clause. Whoever I shall be married to shall be the beneficiary. My current spouse dies. If I remarry, I can access it that way. There's multitudes of ways that we can creatively give access to trust when clients are making these gifts that they need to use their exemption.
Marty, just one tiny point.
Yeah.
I don't think you mean adequate consideration. I think you mean adequate security to make it a grand trust.
Yeah, I misspoke if I said consideration. I meant security. Let's go on to the next slide. GRATs. Does anyone want to comment on what may be with GRATs and how we may want to plan GRATs now?
Sure, I'll comment on that. Look, the issue I think with GRATs, and I feel that you may have hit it in the first bullet point here, is that they may not be an optimal tool in our current environment. With the legislation, with the laws in flux, we typically do plan a GRAT the most effective GRAT tool is a rolling GRAT. So that every 2 years you create another GRAT, or every year you create another GRAT, and keep funding it over and over so that you can pour more of the asset, more of the growth out into a remainder trust. While it is true that the interest rates are relatively low, since we're not sure whether the GRAT strategy will remain viable in the event of a Democratic takeover of the government, I'm not sure if setting up or starting a rolling GRAT strategy at this point makes a lot of sense.
Agreed. A key problem also with GRATs is if you have clients that haven't used their exemptions, GRATs by their very nature are typically structured, almost always structured, to use very limited, or in some people will do with no current gift. I like to have at least some gift, but the point is you use very limited, almost no exemption when you create a GRAT. The point of the current planning environment for most clients is to use up those exemptions before they disappear. Now, by the way, in our October 28th session, we're going to focus on very wealthy, high net worth clients and planning for them. Grats for uber wealthy clients still may make sense, recognizing the limitation that Joy said that you may not be able to roll them if the Dems win, but they may make sense because it's still a tool to shift some wealth out of their estate if they've used all of their exemption. Another thought on grats very quickly. Jonathan pointed out that one of the proposals that Sanders put forth and the Dems may keep is that it's going to cap annual gifts at a total of 20 grand per donor. So if you need to get some chunk of money into a insurance trust for funding future insurance premiums, a one-shot grat where the excess over the 75/20 rate goes into an ILIT may be a useful tool. Let's go on to the next slide. We've already talked about that, so we can go on. Some clients have terminated or are still talking about terminating credit shelter trust, life insurance trust, because, gee, with such a high exemption, why do they need it? We've had a number of people show up in our office that have done just that. We need to educate clients. If you're thinking about doing things like that, stop. The exemption's getting cut in half in 2026, and it may change after the 2020 election. So please don't unravel existing planning. If anything, improve it and enhance it before the election. Let's go on. Jonathan, do you want to give just a quick overview? We don't have a lot of time left. We can go a few minutes over on Kastner, and then maybe Joy will jump in too.
Yeah, in June, the Supreme Court decided 9-0 that North Carolina could not impose its state income tax on a trust which only had the connection to the state of North Carolina because they had a beneficiary to whom the trustee could but did not make distributions. This was a trust created by New York for the man's daughter and her family, and they moved to North Carolina, and North Carolina's statute said that North Carolina could impose its income tax on undistributed trust income if there was a discretionary beneficiary to whom the income could be distributed. It was 9-0 against the state of North Carolina. One of the things is that the court indicated that you have to have a pretty strong connection for the state to impose its tax. In fact, the only one that rang really true to me was if you have a trustee in your state. So if like North Carolina, it didn't have a trustee in the state, but if it had a statute that said you could, and if there was one there, then maybe that would be it. The states use various means to impose the state income tax on trust. But one of the things we can do for all of our clients is try to avoid state income tax. And, I spent a big part of my practice years doing that for people, saved them tremendous amounts of money, and it's something I think that all of us have to be in consideration. In fact, one of the things that I've done lately, because New York is one of the worst states to administer an estate, and it's probably one of the worst states to have income tax imposed because it's so high. In New York City, it's over 12%, beaten out only by a few tenths of a percent by the state of California. So you have someone who dies in New York, and their estate is going to pay income tax. But there are two things you can do. Number one, you can put their assets in a revocable trust, and when they die, make sure you do not have a New York trustee, any New York source income, or any New York situs asset, and that will avoid New York income tax. If you say, no, we have to have assets running through the probate estate, you can direct original probate elsewhere. Alaska, like New York, permits non-residents of the state to have their wills admitted to original probate there. So I've done that a number of times with very, very wealthy clients. And the state of New York has never come in and said, no, you have to pay state income tax. We have no connection to the state except that we happen to have someone who died, a New Yorker. But that, to me, is no different than having a case where the settlor of a trust happened to be a New Yorker. And New York has now conceded. The New York Court of Appeals first held it, but the statutes now say if you don't have a New York fiduciary and you don't have New York source income or a New York situs asset, you can go ahead and avoid all New York taxes except to the extent that they're distributed to a New York beneficiary. That's something really important to consider in your planning with your clients. No one wants to pay state income tax if they don't have to pay. And now, especially in light of the Kastner decision, you've got a pretty good roadmap on how to avoid those taxes.
Thank you.
Yeah, thanks, Jonathan.
Joy,
yeah,
do you want to?
we don't. Go ahead. It's fine.
No, Joy, go on. Please comment.
Oh, all right. So I just wanted to add to what Jonathan was saying, because I would wholeheartedly agree with him. State income tax planning is really where we spend a bulk of our time in counseling clients. And, you know, the move to avoid state income taxes, particularly in states like New York and New Jersey, where I practice, you know, is very important. And what we're seeing a lot of clients doing is creating different structures so that they can continue to serve in some capacity with some controls over the assets without serving as a fiduciary for the purposes of state tax law. So that this way, because the rules in states like New York and New Jersey specifically say you may not have a resident of the state serving as a trustee. So that really leaves people in a situation where they're putting their assets into trust and then they no longer have any control. We are exploring ways to, you know, use different vehicles in order to allow those individuals to retain some measure of control over those assets while still avoiding the state income tax. And again, the planning for those types of things needs to be done in stages, and the earlier you start, the better.
The slides that are coming up ahead, which we're not going to get to because we're out of time, go through a lot of specific planning recommendations and thoughts based on Kastner. And even though the decision was very narrow, the planning implications, as Jonathan indicated, are very broad. Let me just try to summarize. Tom, why don't you just advance to the end of the slide deck where you have the email addresses. For those interested in more information on Kastner, Jonathan and I just recently wrote a large article for Estate Planning Magazine, and if you email either Jonathan or I, our email addresses are there. We'll be happy to send you the article. And if you email Sandy or I, we can send you the article we mentioned planning for the use of DAPs and prenuptial agreements. Our focus today was really to talk about how the landscape may change dramatically after the election. We're not sure that that's going to happen. Nobody is, but it just doesn't seem prudent not to act now. If we can educate clients about step transaction, reciprocal trust, and other issues, it really behooves the clients to get started on the planning process in 2019 before the end of this year and do other steps before the 2020 election. If there's no change in 2020, the same planning we just talked about will benefit those clients before the drop in exemption in 2026. And as Jonathan pointed out in great detail, there's still incredibly beneficial asset protection results that can be achieved from the same planning. So hopefully what we've given you is some practical ideas how to educate clients, motivate them to come in and start planning now, and concrete steps what to do before the 2020 election. Next session that we have is October 28th on this topic, and we'll focus solely on techniques for large estates and some interesting applications of defined value mechanisms. Joy and I were working on some interesting gift tax planning and reporting issues that may be helpful for you, not obviously for the 2018 season, but for 2019. So please join us for the next session. Jonathan, Joy, Sandy, any last words? It's yours.
Thank you, everyone. Looking forward to talking to you in a couple of weeks.
Thank you again for everybody and the opportunity to present on this important topic.
Thank you for joining us. Jonathan, thank you as well. Tom, let's cut off the webinar. Thank you, everybody.